The justice system's undo button. Why the DOJ pulled the Epstein files. The date is February 3, 2026. For a few brief, chaotic hours, the world believed it finally held the skeleton key to the most protected vault in modern history. The United States Department of Justice, after years of stonewalling, had finally hit the publish button on a massive trove of documents, thousands of pages, linked to the Jeffrey Epstein sex trafficking network. But before the global community could even finish downloading the first gigabytes of data, the screen went blank. The files were gone. The official explanation was almost insulting in its simplicity: redaction errors. The DOJ claimed that sensitive information, which should have been blacked out to protect the privacy of victims, was accidentally left visible. But in the high-stakes world of federal litigation, an accident of this magnitude is rarely just a mistake. Was this a genuine bureaucratic failure, or was it a strategic high-level retreat? When documents tied to the most powerful individuals on the planet disappear in the middle of the night, the question stops being about a technical glitch and becomes about a survival instinct. Who was mentioned in those files that made the American justice system hit the panic button? The anatomy of the archive. To understand the gravity of this withdrawal, we must understand what these files actually represent. This wasn't just a collection of old police reports. This was a mosaic of a global shadow empire. The Epstein files, released in 2026, consist of internal FBI investigative memos that had been classified for decades, flight logs from the Lolita Express that had never been fully de-anonymized, and, perhaps most importantly, thousands of pages of financial ledgers. These documents were the hard-won results of years of Freedom of Information Act, or FOIA, lawsuits and relentless transparency battles led by journalists and survivors. For the first time, we were looking at the internal communications between Epstein's fixers and the legal teams of some of the world's largest financial institutions. The goal was simple: to expose the infrastructure of enablement. We wanted to see not just the crimes, but the banks, the law firms, and the political offices that provided the oxygen for Epstein to operate with virtual impunity for 30 years. The victim rights shield. Truth or pretext? The DOJ's primary defense for pulling the files is the protection of survivors. In cases involving sexual violence, especially against minors, redacting names and addresses is a legal and moral mandate. However, this is where the skepticism enters. The Department of Justice employs massive teams of professional redactors and utilizes state-of-the-art AI-driven software specifically designed to prevent these kinds of exposures. How does a system with this level of oversight accidentally release thousands of pages with sensitive names visible? Critics and legal analysts are raising a disturbing possibility that the redaction error is being used as a geopolitical kill switch. By framing the withdrawal as an act of compassion for the survivors, the DOJ effectively silences anyone who demands the immediate re-release of the files. It is the ultimate bureaucratic stalemate. You cannot demand the truth without sounding like you are attacking the privacy of the victims. But many survivors themselves have pointed out that the greatest harm is not the exposure of their names, it is the continued protection of their abusers. The bombshell, the 2000 Trump mentions. Before the files were scrubbed, investigative teams and citizen sleuths began running word count algorithms on the initial data. The results were staggering. As reported by ABC News, the name of former President Donald Trump appeared in these new documents thousands of times. While a name appearing in a file is not evidence of a crime, the sheer volume suggests a level of social, business, and logistical integration that goes far beyond the "we met once or twice at a club" narrative. But it wasn't just Trump. The files allegedly contain gift logs, dinner invitations, and specific flight paths that link him and his associates to Epstein's properties over a period of 2 decades. In the hyper-polarized political climate of 2026, the sudden removal of these files is being viewed through a partisan lens. Trump supporters call it a deep state setup, while his detractors call it a high-level cover-up. Regardless of the politics, the removal of the files ensures that the full context of these mentions remains hidden just as it was reaching the public consciousness. Global compromat, the international fallout. Reports from Al Jazeera and The Guardian have highlighted that the 2026 files act as a map of international power dynamics. Names like Indian Prime Minister Narendra Modi and former Australian Prime Minister Kevin Rudd appeared in various diplomatic and social contexts, triggering media storms in New Delhi and Canberra. In intelligence circles, this is the definition of compromat, compromising material used to gain leverage over political figures. Epstein's archive was, in many ways, a central bank of compromat. The 2026 files allegedly show how Epstein used his connections to infiltrate high-level diplomatic channels, potentially gathering information that could be used to influence foreign policy. When the DOJ pulls these files, they aren't just managing a domestic crisis, they're potentially conducting a global rescue operation to prevent a collapse of trust in several allied governments. If these files stayed public, the fallout could have triggered a wave of resignations and political instability from Europe to Asia. The 2008 echo, a pattern of protection. To understand why the public doesn't trust the DOJ today, we have to look back at the 2008 non-prosecution agreement. This was the sweetheart deal that allowed Epstein to serve a minimal sentence in a private wing of a Florida jail, with the right to leave for work every day. That deal, brokered by federal prosecutors, didn't just protect Epstein, it essentially immunized his unnamed co-conspirators. For many, the events of February 2026 are a digital version of that 2008 deal. It's the system closing ranks. When the DOJ says we made a mistake, the public hears we realized we were telling too much. The credibility of the American justice system is built on the idea that the law applies equally to all. But when the files of a billionaire sex trafficker is treated with more secrecy than national security secrets, that credibility evaporates. The lack of transparency regarding who authorized the pull-down and who is now re-editing the files only deepens the suspicion that the system is protecting its own. The Streisand effect and the decentralized truth. The DOJ made one massive, irreversible miscalculation. They forgot that in 2026, the internet doesn't have an undo button. This is the Streisand effect on a global industrial scale. The more the government tried to hide the information, the more valuable it became. Within minutes of the files being removed from official servers, they were mirrored across decentralized platforms. They were uploaded to the Interplanetary File System, IPFS, encrypted on various blockchains and shared via peer-to-peer networks. Thousands of volunteer OSINT, open-source intelligence researchers, began a collaborative effort to cross-reference the data before it could be cleaned by the government. The DOJ may have cleared its own database, but the documents now live on thousands of private hard drives globally. The state no longer has a monopoly on the truth. We are seeing a new era of citizen forensics where the public is doing the investigative work that the authorities seem unwilling to complete. The shadow docket and the cost of silence. There is a growing concern among legal scholars about what is known as the shadow docket mentality. This refers to the practice of government agencies and courts making monumental decisions behind closed doors, hidden behind technical justifications. By pulling the Epstein files under the guise of administrative error, the DOJ is participating in this culture of shadow justice. If transparency can be switched off like a light bulb, it is no longer transparency, it is permission. The public is being told that they can only see the version of the truth that has been filtered, sanitized, and approved by the very people who failed to stop the crimes in the first place. The cost of this silence is not just the lack of information, it is the total erosion of institutional trust. Once the public believes that the official record is a curated lie, the foundation of a functional democracy begins to crumble. Conclusion: accountability in the age of power. The Epstein case was meant to be the ultimate reckoning for the global elite. It was supposed to be the moment where the world proved that no amount of money, no political title, and no sweetheart deal could protect a criminal from the light of day.
Instead, the 2026 file retraction has become a symbol of the struggle for accountability. The question is no longer just about Epstein. He is gone. The question is about the system he left behind, the network of banks, politicians, and enablers who are still very much in power. As we wait for the corrected version of these files to emerge, we must remain vigilant. We must ask what names were removed, which flight logs were reclassified, and why is the truth so dangerous to the status quo? The battle for the Epstein files proves that the truth is not something the government gives us, it is something we must demand, preserve, and protect. In the end, the only way to ensure that justice is served is to ensure that the light